Hi, everybody. I'd like to talk about this reverse foreclosure that seems to be the new fad in community association law. I did a video back at the end of January called Summary Judgment Against Yourself, and after the newspapers picked up on the story, a lot of clients have been asking whether the so-called reverse foreclosure can be is or can be used appropriately for them. We have to remember that the case upon which the law was based was where the association had already taken title to the unit through foreclosure. It owned the unit. There was a certificate of title already, and the foreclosing bank was just dragging its feet. So there was no other party to the action in the foreclosure concerning title, because the title had already been lost by the borrower that was being sued in the foreclosure, and the who knows where that borrower was, the former unit owner. Who knows where the borrower is? But the association had title, and by asking the judge to enter summary judgment against the association was able to allow the court to impose a transfer of title that the association had taken away from the borrower and convey it to the lender. Now, the vast majority of clients asking about the reverse foreclosure are in a situation where the association is being sued and the association has not yet taken title to the property, but instead the association is either suing or not on its foreclosure, and the bank is suing on its foreclosure, and it's what we call the race to the courthouse steps. Now, in that instance, I'm not sure that the reverse foreclosure is the proper or appropriate way to attempt to resolve the matter, because the association has no title that can be conveyed. The relief sought by the mortgage holder is, of course, a foreclosure sale and eventual return of the title. Well, if you ever read one of the mortgage foreclosure complaints that gets served on an association, somewhere down in paragraph 23 or so, it states that defendant association is being named because it may have some interest in the property arising out of the declaration of condominium or the declaration of restrictions or whatever, and it doesn't seek its remedy against the association is to have its interests deemed to be superior to those of the association. That's it. It doesn't seek title. It doesn't seek money. All it wants is the court to resolve that whatever claim the association has is being wiped out by the foreclosure. So if we are in a situation, if a client or if an association is in a situation where the mortgage foreclosure is dragging on and the association either isn't in lien foreclosure or is in lien foreclosure but does not have title, then I'm not convinced that a court would grant the remedy of actually issuing whatever interest the association has in the property, vest it or convey it, or order the clerk of the court to convey it through a non-judicial sale, which is what happened in the case, and then take the position that, at least from the association's point of view, the lender is now the owner of the property. That's a pretty big stretch, and judges in South Florida are a little bit more in tune with the collapse of the market there. I'm not sure that the reverse foreclosure would work well without title being vested in the association by virtue of its first foreclosure anywhere in the state of Florida, maybe even not in Miami or Broward, because the interest of the association at the time of the foreclosure of the mortgage is only that which stems from the declaration as recorded. It's not title. So this is not a panacea or a magic wand. Often I say to clients, well, if I could wave a magic wand, what would you want? And then they tell me, and they say, well, I'd like to be out of this lawsuit. And after we disabuse the client of the fact that they're in and they can't get out until it's finished, or if they do get out, it's maybe a worse choice than staying in. But whatever the answer is, this is not a magic wand where all of a sudden we file the motion for summary judgment against ourselves, against the association, when the association does not have title. And all of a sudden, it's going to be like Dorothy walking out of her farmhouse and into Oz, where it's all in Technicolor. And I just wanted to let all of you know that this is a very limited remedy under very limited circumstances. And until I reread the law, I came to the conclusion that very few of my clients fit this situation. Maybe only 1 or 2 or 3 of you have situations where you've taken title to property and it's in mortgage foreclosure, and either you can't rent it or you can't sell it, as I've discussed with many of you. And in that case, the reverse foreclosure would be entirely appropriate. But as to the vast majority of you, the reverse foreclosure really is not an appropriate remedy because you have no title to surrender as the result of a successful motion for summary judgment. So every case is individual. You just need to think hard and consider what's appropriate for you with, of course, the input of your counsel. So good luck with it. It's another bullet or whatever you want to say, another tool in the toolkit, but it only applies to a certain limited number of situations. See ya. By the way, sorry about these goofy headphones, but they actually do work better, and I think this sounds better. See ya.